The probate courtroom in Norfolk, Virginia smelled like old upholstery and the particular stillness of a room where large numbers are spoken aloud into a record. My father was at the petitioner's table when I walked in. He had the specific posture of a man who has already done the arithmetic and found it favorable, slightly reclined, one hand flat on the table, the ease of someone who has been waiting in a room he believes he controls. He looked at me when I entered, and something moved across his face that was not quite surprise and not quite recognition, but was in the vicinity of both, the expression of a man who had calculated that I would not be prepared and was now revising that calculation in real time. He did not know about the last page. None of them did. But to understand what was on that last page and why it changed everything, you need to know who my grandfather was and what this family did while I was at sea. My name is Lieutenant Commander Vivian Marsh. I am 42 years old. I am a surface warfare officer currently assigned as Executive Officer of the USS Gettysburg, a Ticonderoga-class guided missile cruiser home-ported in Norfolk, Virginia. Before that assignment, I served as Operations Officer on the USS Leyte Gulf, completed 2 deployments to the Western Pacific, and spent 14 months as a staff officer at Naval Surface Force Atlantic Headquarters, where I managed scheduling and readiness reporting for a fleet of 22 ships. I have been in the United States Navy for 19 years. I commissioned through the Naval Academy in Annapolis, Maryland in 2004, the same year my grandfather retired from the Navy as a Vice Admiral after 38 years of service, which is a coincidence of timing I have always understood as something more than coincidence. My grandfather's name was Vice Admiral Retired Chester Allen Marsh. He died in January of 2022 at 81 years old, of cardiac failure, at his home in Virginia Beach, Virginia, which he had owned since 1987, and which was one of 7 properties included in an estate that his attorney valued at $143 million. He had built that estate across 4 decades through a combination of disciplined investment, real property acquisition, and 2 business partnerships he had entered after retirement, with the same methodical precision he had applied to everything in his professional life. He was not a man who made imprecise decisions. I want to establish that clearly, because it is the organizing fact of everything that follows. The first week of my plebe year at the Naval Academy, my grandfather drove from Virginia Beach to Annapolis on a Saturday morning and took me to breakfast at a diner off Route 450 that no longer exists. He ordered black coffee and scrambled eggs, and he said, across the table, without preamble, "The Navy will teach you many things. The most important one it will not teach you directly. It will teach you by making you responsible for things that can sink." I wrote that down in the small green notebook I kept in my cover pocket during plebe year. I still have the notebook. It is on the bookshelf in my quarters aboard the Gettysburg, between the Naval Institute professional reading list and the photograph of my grandfather in his dress whites at his retirement ceremony, squinting into the Annapolis sun. I had no reason to think the estate would become what it became. That was my error, not my grandfather's. My grandfather had 2 children. My father, Richard Marsh, who is 64 years old, and who spent his career in commercial real estate in Virginia Beach, and who had been, by his own account, and by the family's general understanding, the person closest to my grandfather in his final years, managing his affairs, accompanying him to medical appointments, handling the practical logistics of an elderly man's daily life. And my Aunt Caroline, who lives in San Diego, California, who had a difficult relationship with my grandfather for reasons I understood only partially, and which I will explain. My brother Daniel is 38 years old, 4 years younger than me, who works in finance in Richmond, Virginia, and who had also been present in my grandfather's life in the final years, in the specific way of a person who understood that presence in those years carried a certain strategic value. I want to be precise about my grandfather's relationship with my father, because the precision matters. They were close in the functional sense. My father handled things. He was reliable in the way of a person who shows up and manages logistics and does not create drama. And my grandfather valued reliability the way all military men value it, as the baseline condition for everything else. What my father was not, and what I understood about him clearly by the time I was in my 30s, was honest in the specific way my grandfather was honest, which was honest even when honesty was costly. My father was honest when it was free. That distinction did not surface cleanly in their relationship until the estate. My Tuesday mornings during shore duty looked like this: reveille at 5, a 4-mile run on the base perimeter, breakfast at the galley. At my desk by 0700, reviewing readiness reports and flag message traffic. I kept a photograph of my grandfather on the corner of my desk, the same one from the retirement ceremony, because it reminded me of what the institution we both served looked like at its best. I called him every Sunday when I was not deployed, the same time every week, and we talked for between 20 and 40 minutes about the Navy, about books, about the specific texture of the world as observed by two people who had spent their lives on ships. He never mentioned the estate in those calls. He never mentioned my father's increasing involvement in his financial affairs. He never mentioned the codicil. I found out later that while I was on those Sunday calls, my father had already begun the conversations with the estate attorney that would culminate in the revised codicil filed 11 months before my grandfather died. The warning signs were small and carried the specific quality of things that make sense in one context and reveal themselves as something different in another. My grandfather mentioned my father's name more frequently in the last 2 years of his life than he had in the previous decade. Always in the context of practical things. He handled the insurance renewal. He took me to the cardiologist. He is managing the property tax appeal. I registered this as a son stepping up in his father's final years. That was the benign interpretation, and I chose it because I had no reason yet to choose otherwise. My brother called me twice in the summer of 2021, which was unusual, and both calls were brief and steered away from specific topics when I tried to engage them. I noted the steering and attributed it to the general awkwardness that had always characterized our relationship and moved on. My Aunt Caroline sent me an email in September of 2021 that said simply, "Have you talked to Dad lately about the estate planning?" I responded that I had not, and that I assumed Grandpa had things arranged, and that she should not worry. She did not reply. I was in the Philippine Sea on a scheduled Western Pacific deployment when my grandfather died in January of 2022. I was notified through official channels and was granted emergency leave, which I used to fly home for the funeral and then return to my ship 14 days later because the deployment schedule did not accommodate extended absence, and because I believed at that point that the estate would be handled according to my grandfather's documented wishes, which I had no specific knowledge of but assumed were precise and deliberate because everything about my grandfather was precise and deliberate. I returned from deployment in June of 2022. The estate distribution had been completed in April. I found this out on a Thursday evening in late June in my apartment in Norfolk, when I opened a certified letter from an attorney named Howard Fells at Fells & Associates in Virginia Beach, who identified himself as the attorney of record for the estate of Vice Admiral retired Chester Allen Marsh, and who informed me that the estate had been distributed under the terms of a codicil executed in February of 2021, that the distribution was complete, and that my share under the codicil had been $1.2 million, which had been deposited into the account on file, and which I had not noticed because I had not been monitoring that account closely during deployment. I sat at my kitchen table and read the letter twice. The kitchen was quiet. Outside, the Norfolk summer was doing what Norfolk summers do, thick and still and slightly yellow in the early evening light. My hands did not go cold. What happened was more specific than that. The part of my brain that processes navigational information, that takes in a set of coordinates and a heading and a known speed and calculates where the discrepancy is between where you are and where you should be. That part engaged completely, and everything else went quiet. $1.2 million out of 143 million. I did the fraction. It took about 4 seconds. I called my father. He answered on the second ring. His voice had the careful quality it acquired when he was managing a conversation he had anticipated. I asked him to explain the codicil. He said my grandfather had revised his wishes in the final years to reflect the reality of who had been present and who had contributed to his care and his affairs. He said it was my grandfather's right to distribute his estate as he saw fit. He said I had been, and I want to be exact about this because the phrasing was specific and I have not forgotten it, I had been largely absent due to my career choices, and that my grandfather had understood that and had made his peace with it and had arranged things accordingly. Largely absent due to my career choices. I was in the Philippine Sea serving the United States Navy in the same institution my grandfather had given 38 years of his life to. My father had described this to me as a career choice that justified a distribution that gave me less than 1% of a $143 million estate. I said, "Who witnessed the codicil?" He said the estate attorney and a notary. I said, "Was Caroline notified?" There was a pause. He said Caroline had received her share under the codicil as well. I asked what her share was. He said he did not have the exact figure available. I said I would find it and ended the call. I sat at the table for a while after that. I thought about my grandfather ordering black coffee and scrambled eggs at a diner in 2004 and saying the most important thing the Navy teaches you, it does not teach directly. I thought about 19 years of Sunday phone calls and a photograph on a corner of a desk and a small green notebook from plebe year. I thought about a man who did not make imprecise decisions. And I thought about the specific fact that a man who did not make imprecise decisions had an estate attorney, and that estate attorneys, in my limited but now rapidly expanding understanding of how these things worked, sometimes received instructions in advance for situations their clients anticipated might arise. That was the moment I stopped being the person waiting to understand what had happened. I started being the person who was going to find out. Now I want to be clear about where I was at that point. I had a certified letter, a phone call, and a fraction that did not add up to anything that resembled my grandfather's character. What I did not have yet was any knowledge of what my grandfather's original will said, who had drafted the codicil and under what circumstances, what my Aunt Caroline had actually received, or what the estate attorney's full file contained. What I was about to find, through a process that took 6 weeks and required the same methodical documentation I applied to fleet readiness reporting, was going to change every assumption I had made about how much my grandfather had actually anticipated, and how far in advance he had been preparing for exactly the situation I was now standing in. The first call I made was not to an attorney. It was to my Aunt Caroline in San Diego, California, at 7:15 in the morning Pacific time, which meant I had been awake since 3, calculating what I needed to know before I spoke to anyone with legal authority over the situation. Caroline picked up on the fourth ring with the voice of someone who had been expecting this call for longer than I had been making it. I said, quote, 4. She said, $2.1 million. I said, quote, 5. She said, yes. I said, quote, 6. There was a silence that had weight in it, the specific weight of a person who has been carrying a decision they are not proud of and has been waiting for someone to ask about it directly. She said, quote, 7, quote, I said, quote, 8, quote. She said she had not been shown the original will. I said, quote, 9, quote. She said, quote, 10, quote. I said I was already planning to. She said, quote, 11, quote, I said I would call her back. The attorney I called was a woman named Margaret Solis, a probate and estate litigation specialist in Norfolk with 24 years of practice, who had been recommended to me by the Judge Advocate General's office at Naval Station Norfolk when I called them the morning after receiving Howard Fells's letter and explained the situation. The JAG officer I spoke with was a lieutenant commander who listened to the summary without interrupting and then said, quote, 12. He paused and then said, quote, 13. Margaret met me 2 days later in a conference room on the 7th floor of a building on Granby Street in Norfolk that smelled like coffee and the particular seriousness of a space where consequential things were regularly decided. She was 57 years old, compact and precise, with the unhurried delivery of someone who had long since stopped being surprised by what families did to each other over money. She asked me 3 questions before I had finished sitting down. She asked whether I had a copy of the original will. I said no. She asked whether Howard Fells had provided me with any documentation beyond the letter I had received. I said no. She asked whether my grandfather had ever discussed his estate planning with me directly. I said he had not, but that he had used the same estate attorney for at least 15 years to my knowledge, and that the attorney's name was not Howard Fells. Margaret looked up from her notepad. She said, "What was the name of the original attorney?" I said I did not know his name, but that my grandfather had mentioned his firm once, years ago, during a conversation about the Virginia Beach properties, and that it was a small firm, 2 partners, and that the name had something geographic in it, something about the bay. She typed something on her laptop. She turned the screen toward me. She said, "Chesapeake Estates and Trust, Wallace and Bream, Virginia Beach." I said that sounded correct. She said, "They're still operating. Gerald Wallace has been practicing for 31 years. She looked at me. "Your grandfather's original estate attorney was not Howard Fells." I said I understood. She said, "Then Howard Fells drafted the codicil." I said apparently. She said, "I need you to find out who introduced Howard Fells to your grandfather and when." I drove to Virginia Beach the following morning. I had called Gerald Wallace's office the previous afternoon and identified myself and explained that I was Vice Admiral Chester Marsh's granddaughter and that I had questions about his estate. The assistant had put me on hold for 90 seconds and then come back and said Mr. Wallace would see me the next morning at 9. Gerald Wallace was 63 years old and had the specific quality of a man who has spent 3 decades keeping other people's secrets and has developed a profound respect for the weight of that responsibility. He shook my hand and looked at me for a moment before speaking, the way people look at someone when they are deciding how much to say. Then he said, quote, 20. He sat down. He said, quote, 21. He paused, quote, 22. I started to speak. He held up one hand, not rudely, just the gesture of a man who has more to say. He said, quote, 23. He looked at me steadily. Quote, 24. He reached into the top drawer of his desk and placed a manila envelope on the surface between us. It was sealed with red wax and had my grandfather's signature across the seal in black ink. He called it the last page. The physical sensation when I looked at that envelope was not triumph. It was something quieter and more specific than that. The sensation of a man I had known my entire life reaching across the distance between the living and the dead, and doing exactly what he had always done, which was anticipate the problem, document the solution, and trust the right person to find it. My hands were completely steady. I said, "What does it say?" Gerald said, "I don't know. He sealed it himself. I have followed his instructions exactly. I have not opened it." He said, "I filed the addendum notice with the probate court this morning, which is what he instructed me to do when you came to see me. The sealed document is now part of the official record and will be opened in court." I had everything I needed, but I hadn't told them that yet. I want to be honest about the 3 weeks between Gerald Wallace's office and the probate hearing because they were not clean or organized in the way I am making them sound. I went back to my ship. I stood watch. I ran department head training and maintenance reviews, and prepared for an upcoming readiness assessment that had nothing to do with my grandfather's estate and everything to do with the 22 people in my division whose professional advancement depended on my being present and competent, regardless of what was happening in a probate court in Norfolk. I did both things simultaneously, which is what the Navy trains you to do, and I will not pretend it was easy, because it was not. Margaret filed a formal objection to the estate distribution on the grounds of undue influence and improper execution of the codicil. She subpoenaed Howard Fells's complete file. She requested the medical records from my grandfather's cardiologist for the 18 months preceding the codicil's execution. She contacted Caroline, who agreed to provide a sworn statement about the circumstances of her notification and the pressure she had felt to accept the codicil's terms without review. The subpoenaed file from Howard Fells arrived 3 weeks after the objection was filed. Margaret called me at 0600 on a Tuesday morning, which told me before she said a word that what she had found was significant. She said, quote 29, she paused. Quote 30. She paused again. Quote 31. Your grandfather did not pay for the document that redistributed his estate. I need you to understand what that billing record actually meant. It meant the codicil had not originated with my grandfather's wishes. It had originated with my father's planning, been executed by an attorney my father had retained and paid, and been presented to an 80-year-old man with a failing heart as a document reflecting his own desires. My grandfather had signed it, Gerald Wallace had told me, because he lacked the energy to fight. But he had also walked into his original attorney's office and left a sealed document and specific instructions because he was a man who had spent 38 years in the United States Navy and understood that when you cannot fight the immediate battle, you prepare the conditions for the battle that comes later. Wait, it gets worse. Margaret had also pulled the witness documentation on the codicil. 2 witnesses had signed. The notary was a woman named Patricia Givens, who operated a mobile notary service in Virginia Beach. The second witness was Daniel Marsh. My brother had witnessed the codicil. He had been present in the room when my grandfather signed a document that gave him 3 times my share of an estate worth $143 million. And he had signed his name as a witness, and he had said nothing to me in the months between that signing and my grandfather's death. And nothing in the months between my grandfather's death and the distribution, and nothing in the months between the distribution and my return from deployment. I sat with that information for a long time. I did not call Daniel. Margaret had told me not to contact any party directly, and I followed that instruction precisely, but I want to be accurate about what it cost to follow it, which was the specific discipline of a person who has been trained to operate under conditions that require them to hold still when everything in them wants to move. The medical records from my grandfather's cardiologist covered the 18 months before the codicil's execution and showed a man whose cognitive function had been documented by his physician as intact, but whose physical condition had been significantly compromised. A man who was, in his doctor's specific language, quote, experiencing significant fatigue-related decision-making impairment, end quote, during the period when the codicil was signed. Margaret read me that phrase over the phone and then read it again. She said, quote, 32, quote. I said I understood. She said one more thing. She said, quote, 33, quote. She paused. Quote, 34, quote. I said I knew. She said, quote, 35, quote. I had one hearing left, and I had been waiting for it without knowing I was waiting, since the first Sunday phone call my grandfather ever missed. Everything that followed had been assembled over 6 weeks from subpoenaed billing records and medical files and a sworn statement from my aunt, and a manila envelope sealed in red wax sitting in the custody of the Norfolk probate court. Margaret had told me to let her lead, and I told her I understood that completely, except that I also knew there was one moment in that courtroom, one specific moment, when the sealed envelope would be opened and its contents read into the record, and I had been thinking about that moment since the morning Gerald Wallace had placed it on his desk and told me my grandfather had called it the last page. I had thought about it every morning watch I stood on the Gettysburg between that morning and the hearing date. I knew what I was going to do when it happened, which was nothing at all except be present and let my grandfather speak. We drove to the federal courthouse in Norfolk at 8:31 in the morning. I remember the quality of the light, flat and gray, and very still, the way Norfolk looks in October when the season has finally decided to change. The probate courtroom in Norfolk was smaller than I had expected for the size of what was being decided in it. 6 rows of gallery benches, a raised bench, 2 counsel tables, an American flag to the left of the judge's position, the seal of the Commonwealth of Virginia on the wall. The windows faced east, and the October morning light came through them flat and without warmth. It smelled like carpet, and the specific institutional stillness of a room that had absorbed a great many difficult conversations and retained none of them. I had been in spaces like this in a different context, spaces where the formality of the setting was designed to remind everyone present that what happened here was permanent and on the record. I was not uncomfortable. I sat at the respondents' table with Margaret beside me, and I put my hands flat on the surface, and I looked at the flag, and I waited. My father came in with Howard Fells and their attorney, a man named Calder, who had the practiced ease of someone who had been doing estate litigation for a long time and who believed, based on everything he knew about this case, that he was managing a containable situation. My father wore a dark suit, and the expression he used in professional settings, composed and slightly formal, the expression of a man who expected to be treated as a reasonable person because he had always been treated as one. He looked at me when he sat down. His face did the small recalibration I had seen in Gerald Wallace's office, the micro-adjustment of a man revising an assessment. He looked at the table. He did not look at me again for a long time. Daniel was in the gallery. He had not been named as a party to the proceeding, but he was present, seated in the second row, in a gray suit, with the specific posture of someone who has been told by their attorney to appear neutral and is working at it. He looked at me once when I came in. I looked back. Neither of us moved. Then I turned to the front of the room. The judge was the Honorable Robert Crane, Probate Division, who had been on the bench for 16 years, and who Margaret had described as a man who read every filing before he entered a courtroom and who had a specific intolerance for what he called document irregularities. He entered at 9:04. We stood. He sat, opened the file, looked at it for a moment, and then looked at both counsel tables with the even attention of a man taking inventory. He said he had reviewed the filings and had several preliminary observations. He noted the billing record discrepancy, that the codicil had been paid for by the petitioner rather than the testator, as a matter requiring explanation. He noted the medical record documentation regarding cognitive fatigue during the period of execution. He noted the addendum filing from Gerald Wallace and the existence of the sealed document now in the court's custody. He said he intended to address the sealed document at the appropriate point in the proceeding and that both parties should be prepared for its contents to be read into the record in open court. Calder gave his opening. He was organized and smooth. He framed my father as a devoted son who had managed his father's affairs with diligence and love during the most difficult years of his life. He described the codicil as a voluntary expression of a man's right to direct his own estate. He described my naval career with a careful respect that was designed to make my absence from my grandfather's final years sound like a series of honorable choices rather than the operational requirements of active duty service, which is what they were. He used the word devoted 4 times. He used the word presence 6 times. He was good at his job, and I noted that without resentment, because accuracy requires acknowledging competence, even when it is being deployed against you. Margaret gave our opening in 11 minutes. She named the billing record. She named the date Howard Fells was retained by my father. She named the date the codicil was drafted. She named the date my grandfather visited Gerald Wallace alone and left a sealed document with specific instructions for its delivery to the court. She named the medical record language about fatigue-related decision-making impairment. She named the witness signature. She said Daniel Marsh's name clearly and without emphasis and let it sit in the room for a moment the way you let a navigational fix sit before you act on it. The proceeding moved through its stages. Calder presented my father's account of the codicil's execution, his characterization of my grandfather's wishes, his documentation of the care he had provided. Margaret cross-examined on the billing records. My father said he had paid for the codicil as a courtesy because his father had been managing significant medical expenses. Margaret asked him to identify the specific conversation in which his father had asked him to arrange for codicil drafting. He said the conversation had been informal. She asked him to identify the date. He said he could not recall precisely. She asked him whether he had informed his daughter, who was on active naval deployment, that a codicil affecting her inheritance was being drafted. He said he had not felt it was necessary at that stage. She asked at what stage he would have felt it necessary. He said he would have informed me when the distribution was complete. She said, when it was too late to object. He said that was not how he would characterize it. She said, I understand, and sat down. Judge Crane looked at his notes. Then he looked at the clerk and said it was time to address the sealed document. The clerk brought the manila envelope to the bench. Judge Crane examined the seal, noted for the record that it was intact, and opened it with a letter opener in the specific, deliberate way of a man who understands that what he is doing is permanent. He removed 3 pages of handwritten text. He read them silently for 4 minutes. The courtroom was completely quiet. Outside, through the east windows, a cloud moved across the October sun, and the light in the room shifted slightly and then held. Judge Crane looked up. He said he was going to read the document into the record in its entirety. He said it was dated March 14, 2021, and that it was written in the hand of Vice Admiral retired Chester Allen Marsh, and had been verified as such by Gerald Wallace's sworn affidavit. He read it. My grandfather's handwriting, read aloud by a probate judge in a Norfolk courtroom, sounded like exactly what it was. The voice of a man who had spent 38 years giving orders that could not be imprecise because imprecision cost lives, applied to the final order he would ever give. He wrote that he had signed the codicil because he was tired, and because the conflict it would have required him to sustain was beyond his physical capacity in his current condition. He wrote that he was signing it with the complete understanding that it did not reflect his wishes and that it had been arranged by his son for his son's benefit. He wrote that his original will, executed by Gerald Wallace in 2008 and amended twice since, reflected his actual intentions and that he was instructing the court to treat the original will as controlling in the event of any contest. He wrote that his granddaughter Vivian had served the United States Navy with a distinction that reminded him every day of why he had given his own life to that institution, and that any instrument that reduced her share of his estate on the grounds of that service was an instrument he repudiated entirely. He wrote that he had anticipated this situation from the moment the codicil was presented to him and had prepared accordingly because, and I am going to quote the exact phrase the judge read into the record, because that is what you do when you have been in the Navy for 38 years, and someone tries to run an operation against you. You let them think they have succeeded, and then you make sure they have not. Judge Crane set the pages down. He looked at Calder. He said, quote 38, quote, Calder said he would need time to confer with his client. Judge Crane said he would recess for 30 minutes. My father stood up from the table when the recess was called. He stood up slowly, the way people stand when they are managing something physical. And he turned, and for the first time since we had entered the room, he looked at me directly and held it. Not the recalibration expression from earlier. Something different. something that did not have a clean name, but that was in the territory of a man who has just heard his own father describe him accurately in a public record, and who has no remaining framework for not knowing that. He looked at me for about 4 seconds, then he turned and followed Calder out of the courtroom. I sat at the table and did not move. Margaret put her pen down quietly on her notepad. Outside the windows, the October light had settled back to flat and gray and very still. The room was very quiet. Somewhere in the building, a door opened and closed, and the sound traveled through the corridor and reached us faintly, and then was gone. After the recess, Calder informed Judge Crane that his client was prepared to consent to a full reinstatement of the original will and to withdraw his petition contesting the addendum. Judge Crane accepted the consent and entered a preliminary finding that the codicil had been executed under circumstances consistent with undue influence, and that the original will would govern the estate distribution. He noted for the record that the billing documentation raised questions he was referring to the Virginia State Bar for review of Howard Fells's conduct. He said the complete distribution calculation would be handled by a court-appointed administrator and that both parties would receive formal notification within 60 days. Then he looked at me. He said, "Lieutenant Commander Marsh." I said, "Yes, Your Honor." He said, "Your grandfather's document will remain in the record of this court." He said it the way people say things that are meant to be heard as more than their literal content, and I heard it that way, and I said, "Thank you, Your Honor," and I meant it in the same register. In the parking structure beneath the courthouse, I stood next to Margaret's car for a moment before getting into my own. She said the full distribution calculation would take approximately 3 months and that she expected it to reflect the original will's provisions closely. She said Howard Fell's referral to the State Bar was significant and that she would keep me informed. Then she said, quote, 43. She looked at me. Quote, 44. I said I know, she said. Quote, 45. She shook my hand and got in her car. I sat in my car in the parking structure for about 3 minutes. I did not run cold water over my wrists. I did not do anything specific. I sat in the specific concrete silence of a parking structure in October, and I thought about a man ordering black coffee and scrambled eggs and saying the most important thing the Navy teaches you, it does not teach directly. I thought about 38 years of service and a sealed envelope, and the phrase you let them think they have succeeded, and then you make sure they have not. I thought about 19 years of Sunday phone calls and a green notebook on a shelf on a ship in Norfolk Harbor. Then I started the car and drove back to the Gettysburg because I had a readiness review at 1400 and my division deserved my full attention. My father did not contest the reinstatement. The estate distribution under the original will was finalized 4 months after the hearing. My share under the original will was 31% of the net estate after taxes and fees, which resolved to approximately $38 million. Caroline received 22%. My brother received 14% under the original will's terms, which was less than he had received under the codicil, which I note without gloating because the number is the fact, and the fact is sufficient. Howard Fells received a formal reprimand from the Virginia State Bar and surrendered his probate practice certification 6 months after the hearing. My father has not contacted me since the courthouse parking structure. I have not contacted him. That is not a decision I made in anger. It is simply the current state of things, which I am still in the process of understanding. Daniel called me once, 2 weeks after the hearing. He said he had not known what was in the codicil when he signed as a witness. He said he had signed because their father had told him it was a routine document and that he had trusted that characterization. He said he was sorry he had not asked more questions. He said he was sorry he had not told me. There was a long silence after that, the specific silence of a true thing that is not enough, and we both knew it was not enough, and neither of us knew what would make it enough, and eventually we said goodbye. He has not called since. I have not called him. There is one more thing I have not told you yet. Gerald Wallace sent me a letter 6 months after the hearing. In it, he said that my grandfather had told him, on the day he left the sealed envelope, one additional thing that he had not felt it was his place to share until the legal matter was resolved. He said my grandfather had told him that the reason he trusted me to find the original attorney was not my naval career or my investigative instincts or any specific quality he had observed. It was a conversation we had had on one of our Sunday phone calls in the summer of 2020, 2 years before he died, in which I had asked him who his estate attorney was, and he had said Gerald Wallace at a firm with something geographic in the name, and I had said I would remember that. He had believed me. He had built the entire contingency on the belief that I would remember a name mentioned once in a phone call 18 months before he died. I did remember it. Not perfectly. Imperfectly. Imperfectly enough that Margaret had to type possibilities into a laptop to find it. But I remembered enough. I am back aboard the Gettysburg. It is a Tuesday in November, and I stood the morning watch at 0400, and I am at my desk now with the readiness reports and the photograph of my grandfather in his dress whites on the corner of the desk where it has always been, and the green notebook from Plebe year on the shelf behind me. The notebook is not something I open often. It is something I know is there, which is a different kind of useful. What I actually learned from all of this is not what I expected to learn. I expected to learn something about the specific coldness required to plan an estate theft during a man's final months. What I learned instead was more precise. My grandfather did not fight the codicil because fighting it would have cost him the last months of his life in conflict rather than in peace. He made a tactical decision to absorb a loss in the short term in order to secure the outcome in the long term. He did not tell me what he had done because telling me would have required me to carry it during a deployment, and he had spent 38 years understanding what it cost a person to carry something they could not act on. He waited until I could act, and then he made sure I had everything I needed. The photograph is on the corner of the desk. The green notebook is on the shelf. The last page is in the permanent record of the Norfolk Probate Court, where it will remain. On Sunday mornings I still keep the time I used to call him. I do not call anyone, I just keep the time. It takes about 30 minutes. I have not decided yet what I am doing with those 30 minutes. Whether I am grieving or remembering or simply maintaining a practice, because the practice itself is the point. I think it might be all three. I think he would find that a reasonable allocation of time. The October light through the porthole this morning was flat and gray and very still. The harbor was quiet. I made coffee and opened the reports and went to work. If any of this is familiar to you in some way, I would want to hear about it in the comments below. And if you want to know what my grandfather wrote in the second and third pages of that sealed document, the parts Judge Crane read silently before he read the first page aloud, I have not told that part of the story yet.